तो गुड मॉर्निंग। अभी बज रहे हैं 12। अब तो गुड आफ्टरनून हो गया है वैसे भी। और आज लास्ट डे पढ़ाई कर रहे हैं। और इसके बाद एआई बी को उठा के साइड में डाल देंगे, क्योंकि प्रोविजनल तो हमें मिल ही जाएगा। एआई भी हमारा क्लियर हो या ना हो, तो इसको बस लास्ट पढ़ते हैं। बेयर एक्ट में गया हूँ, अभी बेयर एक्ट को भी देखना है। तो ये सारी बुक्स हैं, तकरीबन 47 बुक्स हैं जो हमें रिक्वायरमेंट होगी। तो अभी हमारे पास कितनी है? 1 2 3 4 5 6 7 8 9 10 11 12 13 14 15 16 17 18। तो ये बुक्स हमको लेकर जानी है कल के एग्जाम में। हमारी लगने वाली है बॉट। इनसे रेफरेंस लेते लेते ये भी कम है, तकरीबन 30 और बुक्स हैं जो हमें रिक्वायरमेंट है। 17 के करीब है। इन्हीं के 47 समथिंग बुक्स हैं, इन्हीं के जो सेक्शंस रेफर्स किए जाते हैं बार काउंसिल के एग्जाम में। तो लेट्स स्टडी, देखते हैं। और मुझे इनको चेक करना है, इनमें कोई मैंने लिख ना रखा हो, मेन चीज वो है। तो इनको बैठ के हम चेक करेंगे बाद में। अभी तक एक बंदा भी नहीं आया है, और पता नहीं और लोगों की। तो अब ये चलेगी 12 बजे तक क्लास। क्लास मतलब लाइव। अभी पता नहीं किस किस के मैसेज आ रहे हैं। पॉलिसी बाजार, और एक बंदा आके चला गया। तो जेमिनाई के हम थ्रू ये जो क्वेश्चन पेपर है इसको सॉल्व कर रहे हैं। Which of the following sentence is correct method? A. The India is considered must follow for the promises only. B. In India, the consideration must follow from only promiser or only promises. C. India's consideration must follow for the promiser or any other person. D.
The correct statement regarding consideration in Indian contract law is C. In India, consideration may move from the promisee or any other person. Explanation based on Indian Contract Act 1872. Section 2D of the Indian Contract Act 1872 defines consideration as when, at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or to abstain from doing something, such act or abstinence or promise is called a consideration for the promise. This definition highlights two key principles of consideration in India that relate to your options. 1. Consideration must move at the desire of the promiser. The act or abstinence must be at the request of the promiser. This rules out option A and C in your original phrases, which incorrectly state that consideration must follow for the promises, implying to the promisee. 2. Consideration may move from the promisee or any other person. This is the crucial point that makes option B, or rather the principle it describes, correct.
Term holders include A. Payer, bearer, endorser, all of the above.
This question appears to be related to the definition of a holder under the Negotiable Instruments Act 1881, Indian law, but with some typographical errors in the options. The most probable correct intended option based on the definition of a holder of a negotiable instrument, like a check or promissory note, is all of the above. Explanation. The question appears to be a multiple choice question where the options have been misspelled or mistyped. The correct legal question and options are typically: the term holder includes A, the payee B, the bearer C, the endorsee D, all of the above, according to Section 8 of the Negotiable Instrument.
Under the Dissolution of Muslims Marriage Act 1939, a Muslim wife can seek the dissolution of marriage if the husband fails to perform marital obligations for 2 years, 3 years, 4 years, 5 years.
Under the Dissolution of Muslim Marriages Act 1939, a Muslim wife can seek the dissolution of her marriage if the husband fails to perform his marital obligations for 3 years. Grounds for judicial divorce, Section 2. This ground is specifically covered under Section 2 IV of the Act. The Act provides several grounds upon which a Muslim wife can obtain a judicial decree for the dissolution of her marriage. Ground, Section 2.
The concept of corrective petition was introduced by the Supreme Court of India in the case of
The concept of a curative petition was introduced by the Supreme Court of India in the landmark case of Rupa Ashokura versus Ashokura and ANR, 2002. Key takeaways. Nature. The curative petition is considered the last judicial remedy available to any person, used only after a review petition, under Article 137 of the Constitution, has been dismissed. Objective. The Supreme Court devised this extraordinary remedy based on its inherent powers to prevent the abuse of its process and to cure a gross miscarriage of justice.
right to fair legal aid was recognized as fundamental rights under the Act of 21 of the Indian Constitution in the case of
The right to free legal aid was first recognized by the Supreme Court of India as an essential fundamental.
in the case of Muhammad Allahabad Khan versus Muhammad Ismail Khan is related to
The case of Muhammad Allahabad Khan versus Muhammad Ismail Khan is a landmark decision in Muslim law that primarily deals with the doctrine of acknowledgement of paternity, iqrar ul-nasab, key principle established. The case, decided by the Allahabad High Court in 1888, is crucial for distinguishing the legal effect of acknowledgement in Islam from the concept of adoption. It established the following core principle. Acknowledgement confers legitimacy when paternity is uncertain. The doctrine of Iqrarul Nasab applies only when the legitimacy of a child is uncertain, i.e., there is no proof of marriage or the marriage itself is in doubt. In such cases, a man's acknowledgement of a child as his son can establish both the child's legitimacy and the presumption of a valid marriage with the mother. Acknowledgement cannot legitimize a child proven illegitimate. The court firmly held that acknowledgement cannot be used to legitimize a child who is known to be the
in which of the case the Supreme Court was in 2017 declared the pronouncements of talaq 3 times at the time of Muslims husband unconstitutional.
The Supreme Court of India declared the practice of talaq ibidat, instantaneous or irrevocable triple talaq, unconstitutional in the landmark 2017 case of Shayara Bano versus Union of India and others, 2017. Key judgment details. Date, August 22nd, 2017. Verdict. The 5-judge Constitution Bench delivered a 3-2 majority verdict, holding that the practice of instant triple talaq was unconstitutional. Reasoning. The majority found that talaq bidat was manifestly arbitrary and violated the fundamental right to equality.
Nisa profit of the property, a those profit by which the person is wrongful possession of such properties actually receive of them might have received their form together with.
The term you are referring to is mesne profits. The definition you provided is essentially the statutory definition of mesne profits under Section 212 of the Code of Civil Procedure 1908 CPC, which governs Indian civil law. Definition of mesne profits. Mesne profits are defined as those profits which the person in wrongful possession of such property actually received or might with ordinary diligence have received therefrom, together with interest on such profits, but shall not include profits due to improvements made by the person in wrongful possession. Key components. 1. Wrongful possession is essential. Mesne profits can only be claimed when the defendant is in unlawful or wrongful possession of immovable property, thereby depriving the rightful owner of its use and income. 2. Compensation, not rent. It is a form of damages or compensation paid for the injury caused by the wrongful deprivation of possession.
Which of the following is not a legal representative? A. The executive of the administrator.
The term legal representative under the Code of Civil Procedure 1908 CPC is defined broadly in Section 211. Based on this definition and judicial interpretations, a person who is not a legal representative is someone who neither represents the estate of the deceased nor intermeddles with it. Common examples of persons not considered a legal representative.
Which one of the following is not a legal representative? Executor of the administrator. B. The Hindu corporants. C. The creditors. D. The intermediary.
The term legal representative under the Code of Civil Procedure 1908 CPC is defined broadly in Section 211. Based on the likely intended options, the one that is not necessarily a legal representative is C. The creditors. Explanation based on CPC Section 211. The definition of a legal representative includes category. Is it a legal representative? Reason. A executor or administrator? Yes. They are appointed by a will or by the court to legally represent the estate of the deceased person. B.
Public interest litigation is relaxation of which of the following requirements? A. The jurisdiction. B. The locus standi. C. B, A and B. D. None of the above.
Public interest litigation, PIL, is a relaxation of the following requirements. C. Both A and B. Specifically, PIL relaxes the strict requirement of A locus standi and often the strict procedural requirements, though your options only list A and B. 1. Relaxation of locus standi. Locus standi, standing to sue, is the traditional legal rule that states only the person whose own fundamental or legal right has been directly infringed has the right to approach the court for a remedy. PIL relaxation. The Supreme Court of India relaxed this rule. Under PIL, any public-spirited citizen or social action group can file a petition on behalf of a group of people who are poor, disadvantaged, or unable to approach the court themselves due to social or economic disabilities. 2. Relaxation of strict procedural requirements. 1.
Which of the following case is not a case of public litigation? Keshav Bharti versus State of Kerala, the Vincent Narayan versus Union of India, Union India versus Association for the Democratic Reform, Vincent Panicula.
The case that is not considered a public interest litigation, PIL, case from the list is Kesavananda Bharati versus State of Kerala, 1973. Explanation. 1. Kesavananda Bharati versus State of Kerala, 1973. Nature of petition. This was a writ petition filed by Swami Kesavananda Bharati, the head of a Hindu religious mutt, in his private capacity challenging the constitutionality of the Kerala Land Reforms Act, which imposed restrictions on the management of his property. Core issue. The fundamental question was the extent of Parliament's power to amend the Constitution, leading to the formulation of the Basic Structure Doctrine. Why it's not a PIL. It was filed by an individual challenging the violation of his own fundamental right to property, specifically the right to manage religiously owned property under Article 26 and constitutional provisions. It did not involve a public-spirited citizen seeking to enforce the rights of a large, disadvantaged group.
Which of the following can be done by a senior advocate according to with the rule of Bar Council India? Make a concession of the behalf of the client on the instruction of the junior advocate. B. The accept the instructions to the draft to the pleading. C. The accept briefly from the clients. D. None of the above.
The only action among the choices that a senior advocate can legally perform, according to the rules of the Bar Council of India, BCI, is A. Make a concession on behalf of the client on the instruction of the junior advocate. Explanation of senior advocate restrictions, BCI rules. The BCI rules impose specific restrictions on senior advocates, which essentially mean they cannot act but must primarily plead, argue the case. Action. Restriction status. Relevant BCI rule. A. Make a concession. Permitted. A senior advocate is free to make a concession or give an undertaking in the course of arguments on behalf of their client, provided they do so on instructions from the junior advocate. Advocate on record. B. Accept.
Latin word injury sin.
The Latin word closest to the meaning of injuring or injury is injuria.
The Latin maxis injuria sin damnum.
The Latin maxim you are referring to is most likely injuria sine damno. It is one of the fundamental maxims in the law of torts, civil wrongs, and means injuria sine damno, Latin word meaning injuria, legal injury, infringement of a legally protected right. Sine, without, damno, damage, actual loss, harm or monetary loss. Meaning and principle, injuria sine damno means infringement of a legal right without actual damage or loss. The principle is that whenever a person's legal right is violated, they have a cause of action.
The Latin word injury sin damno literally means A. The infringement of legal rights without the damage. B. The damage without the infringement's legal rights. C. A and B both. D. All of the above.
The Latin maxim you are asking about, injuria sine damno, often misstated as injuries in demo or injuria sine damnum, literally means A. The infringement of legal rights without the damage. Breakdown of the maxim, Latin word, meaning, contribution to the maxim, injuria, legal injury / infringement of a legal right, the essential wrong committed. Sine, without, the connective word, damno.
The provision related to the claim tribunal is given under the dash of the Motor Vehicle Act, Section 165, Section.
The provision related to the Claims Tribunal, specifically the Motor Accidents Claims Tribunal, MACT, is given under Section 165 of the Motor Vehicles Act 1988. Motor Vehicles Act 1988. Provision. Subject. Details. Section 165. Constitution of Claims Tribunals. This is the main section that empowers the state government to constitute.
The rule of law means A. Equality before the law. B. The supremacy of the law. C. The predominance of legal spirit. D. All of the above.
The rule of law is a fundamental concept in constitutional governance and literally means D. All of the above. It encompasses all the principles listed. Key components of the rule of law, The modern concept of the rule of law is largely attributed to the British jurist A.V. Dicey, who provided three core principles. A. Equality before the law. This means that no person is above the law, and every individual, regardless of their position, whether rich or poor, high or low, is subject to the ordinary law of the land and justiciable by the ordinary courts.
The purpose of quo warranto is the purpose of writ of quo warranto is a compel of public authority to perform the duties, b the restrain the public authority to do the illegal act, c the to ousted legal occupants or to the public post, d all of the above.
The primary purpose of the writ of quo warranto is C. To oust an illegal occupant or usurper from a public post. Explanation of quo warranto. The term quo warranto is a Latin phrase meaning by what authority. It is one of the 5 prerogative writs provided under Articles 32 and 226 of the Indian Constitution. 1. Purpose. Its fundamental objective is to
The Supreme Court of India held that the permanent obligation of every member of the medical performance either the government to the private give a medical aids to the every injured person be brought from the treatment immediately without waiting for the procedure formality in the case A. Common cause versus Union of States, B. The pupil of Union States, C. The permanent Katra versus Union of India, Lakshmi Kant Pandey versus Union of India.
The Supreme Court of India held that it is the permanent obligation of every member of the medical profession, whether in government or private practice, to give medical aid to every injured person immediately without waiting for procedural formalities in the case of C. Parmanand Katara versus Union of India, 1989. The Life First principle. This landmark judgment, delivered in 1989, is one of the most significant rulings expanding the scope of the right to life under Article 21 of the Indian Constitution. The issue. The case was filed as a public interest litigation, PIL, after a newspaper report highlighted the death of an accident victim who was refused immediate treatment by hospitals, as they claimed the case was a medico-legal case requiring police formalities. The ruling, the Supreme Court unequivocally held that the